Dear students, so welcome back to Property Law, almost getting over now, and that is HOE 6011. So we have looked at a lot of different aspects so far. Of course, everything is in Moodle as well, and homework 4 should be up soon. Yeah, I mean, due soon, so the wills part and all that stuff. So you have that to do. And I've also uploaded homework 5 now, so it's available, and I'll talk a bit about it even during the course of this particular lecture today. And then let's see, not much left, so maybe I wrap up things today, complete whatever is left out, and then next week we can already have maybe a discussion, or some we could upload some of your comments on a forum in Moodle, or I could just do a little revision of the various topics considered so far. And I'll also mark out in Moodle whatever is to be studied for the exam and whatever is relevant for you all to know. And then the exam dates, we already have them, right? So that's 19th May, then 26th May, and then 2nd June. And this will be an online exam. So I'll put up all that information as well. So where were we last time? We were looking at nuisance and different types of nuisance issues. Now remember, this is very relevant from a property law perspective. And so there are two types of nuisance that we'll be looking at. One is private nuisance, and then the other one is public nuisance. And they both have their own intricacies and important elements and features. From a purely legal perspective, as I think I may have already spoken about in the past as well, it's very important to distinguish between a private nuisance and a public nuisance, simply because you have different ways of filing a lawsuit, and the parties to the lawsuit are very important considerations, and you have to make sure that all the essential parties to the suit, or the plaint, or the complaint, or whatever, are already there. And this also ties in with the concept of res judicata. So this is again a common law concept which has implications even in the civil law. And basically what it says is that if you're going to try out a matter, it has to be completely tried out, and then once it's done, it cannot be retried again and again and again forever. And a very important element of this would be the requirement that all the necessary parties to the suit, or to the petition, or whatever you call it, are already included from the very beginning itself. And that's very important because a private nuisance is defined as a non trespass invasion of another's interest in the private use and enjoyment of land. All right, so now that would mean, let's say you have a garden and I go walking over your garden. So of course, now that is an issue. Now this is a bit to be careful about, because if I was to walk over your garden, that would be a trespass, obviously. So what we are looking at over here is a non-trespass invasion, and so the perfect example would be of a nuisance, which is an indirect interference with use and enjoyment of your property. And this would mean, let's say you are a neighbor of mine and I have a noisy air conditioner, or I like to have barbecue disco parties, or something like that. And this is an indirect sort of an interference with your use and enjoyment, because maybe you want to rest and enjoy the summer afternoon or something, and then I am your neighbor and I am doing crazy stuff, and that's disturbing you in an indirect way. And if that is the case, then it would be a non-trespass invasion, and in this situation you can then sue me. So that's a private nuisance. And of course, it's very important, because when you look at a trespass, it only becomes a problem if the trespass causes harm. Whereas for it only becomes a problem because it's a trespass. It doesn't matter whether it causes harm or not. So if I walk over your property, then that's a trespass. You cannot, you don't have to be forced to say that, well, Pawan has damaged my grass, or done something of that sort. No, trespass is trespass. But a nuisance is only liable if there is a significant harm that is caused. Yeah, so that's again a very important consideration to keep in mind. And so again, this brings up the conflicting interests of different landowners, and very often, you have some silly conflicts which can then become more serious. And when they cause an injury to somebody else's legal rights, then of course, it's a issue. It's an issue. So a little bit of inconvenience and annoyance is not what is considered over here, but it's basically a reasonable use of property of others. And if only the use is not in a reasonable term or context, or is unreasonable, then that is the only situation when you can actually have a claim for a private nuisance. So the striking of a balance, of course, is the key, and it includes various aspects like the extent of the harm involved, the character of the harm involved, the social value, that the law attaches to the type of use or enjoyment which has been invaded, then the suitability, the burden of the person harmed of avoiding the harm. All of these are interlinked in a way. So for example, smoking. Yeah, so let's say I'm your neighbor and I smoke, and the smoke causes asthma attacks for you. Then of course in that situation, the question again is, what is the social value to this smoking aspect? Because remember, in the past, people smoked a lot, yeah, really a lot of cigarettes, but not anymore. So the social value of smoking is no longer seen as being of high relevance. Then maybe nude sunbathing. Yeah, it's sunny and you want to take your clothes off. And if you do that in such a way that, well, you're covered from the public, but there is one neighbor who ends up getting to see a lot more of you than she or he would prefer, then in that case, again, it's a private nuisance. Yeah. So I want to sit down quietly and have my breakfast or my lunch or something with my children, and then out of the window is my neighbor, and he or she is sunbathing naked, and I'm the only person, or my window is the only one that's facing them. And so of course this causes maybe a bit of inconvenience or annoyance, or maybe even more, to me and my family. So the key element over here, of course, is that it has to be private and not public. Because if it's private, then I can sue you, you can sue me, and the parties to the suit or the petition or whatever are clear and straightforward. So, of course, the defendant's conduct also has to be viewed in different contexts, and whether it's possible or practicable to actually prevent or avoid this invasion, and all of these are, of course, relevant aspects. But you have to understand that there are always hypersensitive plaintiffs, and this was also a matter which went to the European Court of Human Rights. So there was this 85-year-old guy, and he was very upset because there was a kindergarten next door, and overlooking. He could overlook their kindergarten and the garden, and the children would play and run around and jump and make noises, and so he was very upset about this. So is this an invasion of privacy? Similarly, there was another situation where there was some old guy who used to smoke a lot of cigarettes, and his young neighbor complained. So again, you see, there are a lot of these aspects, and the question that comes up here is how much is too much. And if you have a hypersensitive plaintiff, then of course, this could be an issue, because you could then prove that this neighbor is abnormally susceptible to conduct that would not bother most persons. And then, of course, there is also this aspect of permission. If the plaintiff has permitted the defendant's conduct and then, goes back on this, then of course there is acquiescence or estoppel. Then there is the lashes, that would be delay, undue delay. So, I've been barbecuing for the last 8 years, and now in the ninth year you come and say that you are my neighbor and you don't like my barbecuing. That's an issue here. and the delay can prejudice the defendant. Then, of course, the question is first in time, first in right, and this is a very relevant situation that comes up a lot. So you want to live in the countryside, and so you move out of the city, and now you go and live on a little cottage on in the countryside, and next door is 100-year-old poultry farm or a cow farm or dairy farm or something. And now you are this new person who has come into the neighborhood, and already you are complaining and saying that you don't like the smell. Well, you know, um, they were there before you. So if they were first in time, then they have the first right to be there. And of course, there could also be other issues, like several jobs may be at stake. You are just a city person and you're not happy with the smell of hens or ducks or whatever, but maybe 10, 15, 20 people actually work on that poultry farm, and they could all end up losing their jobs simply because you don't like the smell in your new neighborhood. So again, is a lot of these issues can come up, and the resolutions are usually one of four possibilities. One is defendant is liable, yeah, and an injunction can be issued restraining such conduct. So, your barbecue disco neighbor, defendant might be found liable and damages may be ordered to compensate the plaintiff. So, this is again a situation here, like maybe you are next door to a restaurant, and the noise and the smells and all that cooking and everything disturbs you, but you can't shift the restaurant, but instead they can pay you damages. Then the defendant might be found innocent, in which case there are no recourse for injunctions or any other possibilities. And lastly, the defendant may be innocent, but in this case, the plaintiff has the possibility to pay, and the defendant will leave. Yeah. So you like to live in the countryside, and you don't like that poultry farm next door. Okay, fine. Pay 2 million, and the poultry farm guys will go and shift somewhere else. So of course, these are different aspects. None of these are simple, and none of the solutions are ideal. But that's the world we live in, and very often these things come up. If you look online, for example, there's always this complaint. Some superstar, rock star, somebody has gone and bought a nice little castle or something in Scotland or somewhere else, some remote location. And then it turns out that the Air Force always conducts practices in that area, or maybe there is some Air Force base in that area. And well, that's the reason why they conduct their exercises, because they can't do such things on top of Tallinn or Helsinki or something, because if there's an accident, people could die, who are down in the civilians. So the military likes to practice in far-flung remote areas, and well, they tend to be noisy in whatever they do. So if you buy a manor house or a castle in Scotland, then you can't really complain that the Royal Air Force is conducting exercises there. And this actually came up. I don't know who it was, Bruce Springsteen, or somebody, some singer had a problem. So this can always be an issue. Then there have always been a lot of other issues. For example, with the Facebook guy, Mark Zuckerberg, he has this real crazy need for security and privacy. It's crazy because Facebook tells you, you don't have to worry about privacy concerns. And here is this guy, the owner of Facebook, and he builds up like 20-meter high walls. And he had a house in Hawaii, and then he bought 3-4 neighboring houses, and so made a little fortress for himself with 10-meter high walls. And all the neighbors got upset because what the hell, it's a nice prime location in Hawaii, and now this guy is taking over half the island and building an ugly wall all around. And he's saying, well, it's for my own privacy and things. And they're like, what do you mean your privacy? So a lot of these issues are in the category of nuisance, and it could also be annoyance. It could also be a restriction or obstruction of views towards natural beauty sites or whatever, landscapes or whatever. So all of this is something that comes up over here. The only trick is to remember there is private nuisance and public nuisance. So we'll talk about public soon as well. And so there are some examples from the Estonian law. Then there's something about the ancient lights doctrine. We spoke a bit about this, or rather I did in a previous lecture. But here we're looking more at unreasonable obstruction of access to sunlight in the context of being a private nuisance. And so there's this case of Pram versus Marity. I spoke about it last time also. And even though the new house which is built by the neighbor conforms with the zoning regulations, the fact is that this new construction is now preventing sunshine from coming to the uh, neighbor's solar heated, photovoltaic cell arrangement, or solar plates or whatever they have there. And so this is again an interesting view of how the compliance is there with the zoning laws, but it causes still nonetheless private nuisance. And then the Anthony Stephen Davies case, which I've spoken about as well regarding the view. Again, it's very important to see here that planning permission was still given. Yeah, so legally, there's nothing preventing this person from making their extensions or whatever, because as far as the city government is concerned, it's okay. Now the bigger issue here is that for the neighbors it's not okay, because it sort of blocks the river view. And those of you who know a bit about real estate, you see this is what can push the property prices up or down. Yeah, so you live right next to the River Thames, and then you can see the river, and you can see the Houses of Parliament or whatever in London. Then of course it's worth a lot more money than if you live just 2 blocks away. So of course these are all situations that play a big role, sea facing views, and things like that. And so this is again an instance of private nuisance. And you can read both these cases to get a better idea of what is a relevant issue or matter over here. So having spoken about private nuisance and the relevance of the fact that you can now sue on a one-to-one basis, we look at a public nuisance. And public nuisance in an English context would be a situation taken from older laws where everything was owned by the king or the queen. And so if you want to go on a road, well, who owns the road? The king or the queen. So if you cause an obstruction on the road, if you block the road, if you commit a robbery on the road, then that would mean that you are committing a crime or a criminal offense or whatever offense against a property that belongs to the king. So it becomes a royal offense in a way. And of course, this is how criminal law originated. But now it has been watered down over a period of time. And so you have public nuisance, which basically deals with unreasonable interference with a right common to the general public. And what would this be? This would be, for example, obstruction of a public road. Yep, we have seen that. Maybe keeping diseased animals at home. Yeah, so you like to keep horses in your flat, and especially horses which are terminally ill or something. Well, yeah, that's a very noble thing to do, but it's of course a public nuisance, because this can affect a lot of your neighbors, not just one or two. Or holding a rock concert, or nude sunbathing, or whatever. So all of these are instances of public nuisance, and they are outlined by the laws of the state, which clearly stipulate that this is a public nuisance. And so now there's this case over here, the Armory Park Neighborhood Association case, which basically was that there was this residential area, and then one particular Episcopal Community Services Society had also a house over there, and everybody else lived over there. So everybody was happy-go-lucky, and family place, and everybody had young families and children everywhere, and stuff like that. And now these Episcopal Community Services people decided to open a soup kitchen for homeless and destitute people. So I think they said, like, every day at 12 o'clock, come over and you get free soup. And now everybody from all over the town, from different parts, would all land up over there. Already at 9 o'clock, there would be a carnival and a fun time, and crowds would build up. and now these people would be waiting for the soup and then enjoying themselves, having a good time, walking over other people's gardens or properties, and then urinating everywhere, puking, whatever, and stuff like that. So the other neighbors got upset, and they of course said, you got to stop this because this is causing a nuisance to all the others. So now the question that comes up here is this a public nuisance or is this a private nuisance? Because you see, if it's a private nuisance, it's my neighbor and me. I have a problem with my neighbor. In that case, I can sue my neighbor. But here, what do you have? Here you have uh, lots of people coming and going, outsiders, and a lot of neighbors being affected at the same time. And so, of course, this is an interesting area to look at. And you can also see in this case law how it was then decided whether this would be public or private. Because this is a very preliminary matter for the court to decide who are the essential parties to the suit. The court will have to look at certain things first before the matter can even be taken up for hearing. Does the court have jurisdiction? Yeah. Jurisdiction could be pecuniary jurisdiction in context of money. It could be territorial jurisdiction. It could be regarding the legal matter, the topic of the matter, things like that. So for example, if it's a divorce matter, you go to a family court. If it's a criminal matter, you go to a criminal court, things like that. So that's one thing that the court looks even before it starts to investigate the case itself. Or not rather investigate, but rather hear the case itself. Another aspect that the court would look at is, are all the necessary parties to the suit involved? So if here you have a neighborhood with 35 houses, then the court will ask, how come you're the only one who's over here in the court? Are you representing all 35 houses, or are you in your personal capacity, etc., etc.? But more importantly, this Armory Park case also brings to mind another attitude, which is not in my backyard, NIMBY as they call it. And we see that a lot of times. Yeah? Like I understand now, Finland is in the process of constructing this really big, super huge nuclear reactor. And then the question will be, well, where should this nuclear reactor be? Yeah, should it be next to the zoo in Helsinki? No. Should it be at Vanta? Of course not. That's a super crowded area. Should it be in the middle of nowhere? Should it be next to the Estonian border or the Russian border or the Swedish border? So a lot of these questions come up, and these often are now in the context of political sciences and things. Well, it's the politically vulnerable groups who are the most affected. So let's say there's an issue where you have to make a nuclear reactor or a waste dump or something, and the choice is either a place where a lot of rich people have homes, or then a place where there are some gypsy families who have been squatting for several decades. Well, very often the decision is made that, yeah, you can get rid of the gypsy families. Now you see, this is so politically incorrect, but this is not in my backyard. And then again, this is a more deeper issue. It's not just property law here now. This is also human right law and equality and things like that. And we see that a lot, very often, especially in the context of surface water, which is the next topic I'll be talking about. And this came up in a big way in the 1930s, especially in the United States, because, well, you often know, this Mississippi River goes all the way, and during that time of the year, it always gets flooded because of rains and the Rocky Mountains, and all the snow starts melting and things. And then you often hear about all these floods that happen, and to control these floods, they had built levees, and these are these tall walls on the banks of the river. And the whole idea now is that, well, if there is going to be some sort of an issue with over flooding, then you can just open one or two gates and flood one particular part to save other parts. So let's say if this is the river here, and it finally goes into the sea, and so this is the sea, and this is the sea, and this is the river, long winding river, and all along the river at the weak points they have levees, and these are these thick walls that are built all around. So these are the known areas which have low-lying areas, and they are very prone to flooding. So now, once every 10 years, 20 years, there's always an issue that you have towns over here, you have towns over here, and you have towns and villages over here. And so here you have three of these. So the question is, well, you have to breach this somewhere, this river. The excess water needs to go out. It's all going to the sea, but if you breach it here, then it can all flood here and go to the sea here. Or if you breach it here, it can all go here. Now, of course, they try to do this in as less invasive a way as possible, so that, well, of course, if you were to breach it over here, for example, then two towns, villages, and a lot of farmland could get affected. See, so maybe this side is not an option. But this side was a place where there were some poor black families, liberated slaves, and things like that, who had been living there and were not doing very well. So this part of the side of the river was of very wealthy white families and farmers with very productive lands, and this side was where just some black immigrant families were staying. And this was the 1930s. And guess what? Well, every time they had to flood the river, they would flood it from here. So of course, the question that comes up here is this the most reasonable approach, that you just break the levees here so that the water floods out over here, the pressure gets reduced on this side, and then eventually the water goes to the sea, and in the meantime also knocks out all the land and causes a lot of devastation over here in these houses of the poor people. So this is again property management, you would say, in a weird way. This is about managing water resources, but again, you say this is a conscious decision. If it's made every time, and as a result of it, the politically vulnerable or the poor people are the ones who get affected, then obviously we have a more bigger, deeper bias issue here than just management of water resources and property rights. So this is about surface water, and of course, water can cause a lot of damage. If you have seen in the news, for example, very often when towns and cities get flooded, in mountainous regions, wherever, it causes a lot of devastation. And if you remember, there was this big flooding in New Orleans, and the water was 3 meters high, and it was like that for several weeks. And then of course, this water then mixes up with all chemical wastes and biological wastes and everything, and it becomes a real soup, just destroying whatever it touches. And all the houses that get flooded are, of course, they're not livable anymore. All the property gets destroyed. You have to tear down the houses, because then you have fungi and rotting happening, and all sorts of chemical wastes and everything are deposited all over. So the question that comes up here is, how do you get rid of this water, excess water? So if you are living next to a river, you are going to have this problem. All right, that river is not going to be pretty forever. You are going to have problems in autumn and spring, when the snow starts melting, when it rains a lot. There will be flooding issues. And especially in the United States, you have a lot of these problems, because there people have ranches and big farms, and talking about maybe 200 hectares or something like that, and that's a lot of land. And especially in Texas, New Mexico, all these places. And so very often it's a big debate and issue about how to manage water resources. So if there's a river that's going through multiple people's properties, who has the right to take the water and how much? And can the person who's upstream take all the water and build a dam? And then what happens to the people who are downstream, right? So that's over here. If you're here, you're upstream, and then you are down here, downstream. And of course, if you set up a factory here and put all your waste into the river here, then it sort of has a very bad effect on all the people who are downstream. So if you really want, then you should have a factory more closer to the sea, in the sense that then the waste, which is of course treated, would then go directly into the sea without affecting all the people who are on the way. And again, this causes a lot more problems because then you have fishing communities, and then you have, all sorts of naturalists and everybody complaining about pollution. So a lot of stuff happens with rainwater and river waters and things like that. And it's also a big issue, especially again, there's a lot in the United States in this regard, in the legal literature, regarding how much anybody has rights to take out water as resources. And so older farms in the United States, in Texas, Mexico, New Mexico, and other such places, have a higher premium price because they have water rights to certain wells and things in their properties. But the newer farms, they have restrictions. They cannot drill for groundwater because it's a restricted source. And so again, you see, all of this plays a big role in the economics of how much the property sells for, how it can be utilized, and to what extent. So there is homework 5. It's about this miniature golf course. It's also a case law, but again, in this particular situation, I'm not interested so much in who is right or wrong, but rather there is this aspect that is discussed, and there are certain doctrines, 3 of them. So you just have to look at these 3 and sort of try to figure out what you feel is the most appropriate approach. And then later I'll make the case law available as well, so that you can see whether you were in line with what the court was thinking. All right. Now remember, very often what courts think can become not so relevant because in the future things change. So what a court decided 10 years or 25 years ago may not be relevant anymore today. So again, of course, you have to sort of see that the case laws and the court judgments and decisions can change sometimes over a period of time, or lose their relevance, or become even more relevant. And on the other hand, there are some doctrines, legal doctrines, which are more or less time lasting, and they have their own relevance forever. So the first doctrine was that landowners have an unlimited privilege to deal with surface water on their land as they pleased, and they don't have to care about anybody downstream. So if you are here, you're the top dog, you can do whatever, you don't have to care about people downstream. Now, this is of course a recipe for disaster, right? Because obviously you will have a lot of problems with people downstream complaining about the guy upstream. Then the alternative rule is that the person upstream has an easement, especially in the case of naturally flowing downhill water, and they should not cause any disturbances to this free flow of water. So the water free flow should be not restricted, and of course, if you do cause any impediments, then you are liable if the effects of somebody else are affected, and this is purely based on gravity and the natural flow. And so again, this is a problem because whatever the upriver guy does will cause problems to people down, and so this is going to have some issue or the other. And whatever the people downstream do, if they make a dam or something, it will have an effect on people upstream. So there's no escaping the situation. So the third doctrine is basically the doctrine of reasonable use, and basically it says that everybody has legal rights and responsibilities, and they have to use their land in a reasonable manner. And if it's unreasonably used, then of course it's a problem. All right. So basically here we're looking at is whether it's intentional, and in that case it has to be reasonable, and if it's unintentional, whether it is negligent. So there are some aspects of this that are covered under the different statutes, and well, that's it. So all the lectures are done. Now we just need to have a revision lecture, and next week I'll talk a bit about different issues and things to look at, and then maybe I'll put up this forum open, and then people can have some questions or anything in with regard to the exam or the the notes, or if something doesn't make sense, or if you need some clarifications. And I'm sorry we couldn't meet at all this year in the class, So physically it was not possible. Regarding MS Teams and Zoom meetings, doesn't always work out with 25, 35 people. And from what I understood, I think it appears that most of the students are quite happy with the way things are. Yeah, well, this pandemic will not last forever, so you will have to eventually come to the classroom someday, but I guess not in this academic term at least. So thank you for your time, and I wish you a good week, and then we meet again next week, and I'll do a brief revision, and that should sort of wrap up whatever has been covered, and we'll also look at what is important from the exam viewpoint as such. So until then, thank you for your time, and see you next week. Goodbye.